Okay, I'm still looking at the uh, people coming in, and so we just wait for a few more seconds before we really get started. Okay, so we waited for 2 minutes, and I think we should get started. Welcome everyone to the Scan the Globe webinar series. This is the third installment of our webinar series, and this started as a part of the 125th anniversary of AIPPI, which we celebrated last year. And this webinar series will go on for we don't see any end to it. We will keep going as we cover the the IP situation in every corner of the world. And the idea is that we have more knowledge in the area which are, well, I would say lesser known to us, but still where the economy is growing, and that the importance of the IP is increasing. Okay, so once again, welcome to the Scan the Globe webinar series. And I just hand over to Martin for the housekeeping matters and also the substance of the today's program. Martin.
Thank you very much, Shoiki, and thank you very much, IPPI. On behalf of ASIPI, I would like to thank you for inviting us to cooperate with this webinar. We are very honored and glad to be part of this event. Thank you also to all attendees, and I hope you will enjoy this webinar and these great speakers we have today. Well, before introducing our speakers, there's some housekeeping notes to keep in mind today. There will be a short question and answer session after each presentation, so you can do your questions after the presentation of each one of the speakers. The questions shall be submitted via the Q&A function that you have here in the Zoom chat. Any technical problems, please, you can send a message via also the chat function to IPPI events. The recording and the slides from today will be available upon request to that email that appears there, events@ippi.org. And there is a brief survey after the webinar that we will appreciate if you can complete it and send it back to IPPI. Well, so now moving forward, I will make a short presentation of each of our wonderful speakers of today, according to the order in which they will be speaking. We firstly have Carlos Solarte from Colombia. Carlos will be talking about the Andean community and Chile. He's a founding partner of the Colombian law firm Olarte Moure. His 30-year practice focuses on patent law, including drafting, prosecution, litigation, monetization, and transactional matters. A good portion of his practice focuses on global 100 companies in the life science and telecom space. Another important client base includes local universities and deep tech startups. He graduated from Duke University, where he majored in biomedical and mechanical engineering. He subsequently received his JD from Chicago Kent College of Law and later convalidated his law degree in Colombia at the Universidad Javeriana in Bogotá. He is a member of the state of Illinois and Colombian bars, and he was for many years an adjunct professor of patent law at the Universidad Externado de Colombia. Thank you, Carlos, for being with us today. Then we'll be speaking Felipe Fonteles Cabral from Daneman Simpson, Brazil. Felipe will be providing information about Brazil, Dominican Republic, and Jamaica. Felipe is a lawyer and partner at the Brazilian law firm Daneman Simpson with over 25 years of practice in intellectual property. Graduated in law, also holds a master's degree in law from Rio de Janeiro State University, and currently is engaged in PhD program at the same university, conducting research about artificial intelligence regulation. Felipe's work has been recognized in publications such as Chambers, World Trademark Review, LACA, and Who's Who Legal, and he's the author of the book Personal Data Protection in Corporate Activities, which is recommended by the Brazilian Superior Court of Justice. Thank you very much, Felipe, also for being with us today. Then we will have Agustina Fernandez from Fernandez Seco and Asociados in Uruguay. Agustina will be speaking about Uruguay and Paraguay. She is a partner at the Uruguayan law firm Fernandez Seco and Asociados, where she directs the litigation area of Intellectual Property Department. She is president of the Uruguayan Association of Intellectual Property Agents and of the Data Protection Committee of ACIPI. She is a member of the Data Protection Committee of INTA, of the Uruguayan Bar Association, of the Association of Uruguayan Notaries, of the Argentinian Association of Intellectual Property Agents, and of the Association of Uruguayan Businesswomen. And likewise, she is lawyer and pro bono notary of the Animatech Civil Association. Thank you very much, Agustina, for joining us. And then lastly, but not least, we have Laura Collada from Dumont, Mexico. Laura will be speaking about Mexico and Costa Rica. Laura is the managing partner of the Mexican firm Dumont with over 35 years experience in intellectual property. Her practice includes the complete life cycle of IP rights from advising to litigation and enforcement, as well as licensing. She is a litigator both in the trademark and patent fields. Laura started in the field of a renowned IP firm and then moved to work at the Mexican Trademark Office, where she was the subdirector for the prevention of unfair competition in charge of all infringement. Thank you, Laura, for joining this webinar today. So well, having done the introduction of all of our four great speakers of today, Carlos, you can start. The public is yours.
Martin, thank you very much for that very kind introduction. As you noted, I will be talking about the Andean community in Chile, which have 15 minutes. So the idea really is to give you a high-level introduction on this area of the world, in particular, Andean community in Chile. I'm going to be focusing essentially on some prosecution statistics and some high-level information for the countries involved, as well as some more detail, which I thought was relevant regarding litigation for Colombia. My practice is focused on Colombia. I'm a Colombian attorney. That's where my practice is. But I've received the kind support and validation from a number of colleagues in the rest of the Andean community, which includes Peru, Bolivia, and Ecuador, as well as Chile. And also asked Whiteboard for a little help on the statistics for this presentation. So with that aside, I'd like to go in and talk a little bit about the Andean community then and Chile. As I noted, there is a community. Think a little bit of the European Union. Currently, the 4 members are Colombia, Ecuador, Peru, and Bolivia in the dark blue on the map. Originally in 1969, when this got kicked off, it included Chile as well. Chile left relatively quickly, and Venezuela joined. Venezuela left officially in 2006. So now we're 4 countries, again, Colombia, Ecuador, Peru, and Bolivia. We have a common IP law, which is called right now Decision 486. Those Andean laws are called decisions, and they are issued by the Commission. The Commission is made up of the ministries of foreign trade of each of the 4 countries. So if you want to lobby IP in those 4 countries, you don't go to Congress. You don't go to the Congress people. They have no ability to issue IP laws. You have to go lobby the executive branch in each of these 4 countries. And through the trade ministries, they sit and often sit together. Well, now that we're back into in-person meetings, those meetings take place in Lima at the Secretariat. There's also an Andean Court of Justice that sits in Quito, and they are charged with reviewing, among other things, issues of Andean law, which again includes IP. So many times important decisions or decisions involving IP issues must be submitted to the Andean Court of Justice, which sits in Quito again, and they are charged with, among other things, again, harmonizing, maintaining uniformity in the application of Andean law, including Andean Decision 486, which is the IP law. The Andean community also has an executive branch itself, which is the Secretariat, sits in Lima, and among other things in the IP world, they typically organize efforts to regulate some of the laws. So there's some regulations, for example, the Andean Patent Manual has been the effort of the Andean Secretariat with the help of the EPO and WIPO, for example. And finally, there is a parliament, which, unlike the EU, is merely political. They make recommendations. It sits in Bogota. They are commonly elected, but the people that make the laws are really, again, the foreign trade ministers of each of these 4 countries. Chile is still an associate member of the Andean community. They have voice, no vote, but Chile has its own IP laws. Speaking of that, each of these 4 countries has their own IP office, their own patent and trademark office, and each is in charge of reviewing, for example, if trademarks and patents meet the standards for registrability or patentability, as the case may be. Also worth noting, the Chilean Patent Office is an international search authority. So outside of Brazil, it's the other South American country that you can designate as a search office. They're quite good. And they do a really great job. So a shout out to the Chilean Patent Office for that. As far as IP treaties in the Andean community in Chile, so on the left side, we listed some well-known treaties for these countries, Andean community and Chile. So WTO and TRIPS, all of these countries are members, Paris Convention, all of them. PCT, all of them except for Bolivia. Madrid Protocol, only Colombia and Chile. Trademark Law Treaty, Colombia, Chile, and Peru. Pan American Convention on Trademark and Trade Name Protection, the Berne Convention, and we also have a Pacific Alliance, which includes Colombia, Chile, Peru, and Mexico. As far as the Andean community law, specifically, again, Colombia, Ecuador, Peru, and Bolivia, we have Decision 486, which is a essentially TRIPS compliant decision that came into effect in 2000 for your typical intellectual property regimes. Then you have Decision 345, that's a little older, that's for plant breeders. Decision 291 talks about tech transfer. 351 is copyright, and 391 is also included in an IP because it has a number of regulations governing genetic resources and traditional knowledge and the access to them and their impact in the IP world, which I assume many folks in the audience are accustomed to. There's also a couple of other agreements worth mentioning. Colombia and Peru are members of a number of, most, I think, PPHs, including the Global PPH. And I think all of them have PPHs with the IP5 offices, for example. So it's something worth studying or taking into account if you're filing in this area of the world. And there's also a number of bilateral free trade agreements that many of these countries have signed with the United States and the European Union. Moving on to some trademark statistics. I put these in a table. You're welcome to peruse to them, obviously, on your own. I think it's worth noting that Chile, notwithstanding not the biggest country in my list, still has a preponderance of the applications in the region. Peru took over Colombia, I noticed, in 2021. And what each year has here is the number of total applications, the registrations issued that year, not necessarily corresponding to the applications by year, and of the applications, how many are filed by residents versus foreign applicants. And as you will note, the amount of residents is important as a majority in these countries. Also, I think relevant for trademark stats, quickest country in my list, Peru, average of 3 to 5 months. And then you have the remaining countries, Colombia, Chile, Ecuador, Bolivia. And this is a very, very rough average, assuming oppositions, for example, aren't filed. As far as patents, these are a list of the average patent filings, and I'm sorry, the averages over the past 4 to 5 years. And there is some variation, obviously, if you throw the pandemic in there. But Chile has the most filings on average per year. And of those, the resident filings are 13%. A big majority are foreign applicants, and that essentially is reproduced in the other countries. Colombia has the highest number of domestic applicants, and much of that responds to the Colombian government's support for preparing national filings, drafting. So we've had a spike in domestic filings, but these are the numbers you will see of filings before the local patent office. As far as prosecution stats for patents, Colombia and Chile are the fastest. Colombia is quite fast, 24 months on average right now to a grant from time of filing, and for Chile, 40 months. The Bolivia and Ecuador are still quite slow, 8 to 10 years on average for a final decision. As far as, and I mentioned this again, there are PPH agreements. It's a question worth making, and they are quite useful for reducing times in Peru and Chile, especially if you conform your claims to the PPH country you're citing as your source. Also worth noting, the Andean Patent Manual was updated in 2022, adding clarity and uniformity to patent prosecution throughout the Andean region. And although it's not binding, it is persuasive to be able to cite a common text. And what you typically see in any case are examiners complying or applying what is available in the guide in this patent manual. This is my last slide to end my presentation. I noted I was going to mention some points regarding litigation for Colombia. and some of this can be extrapolated to other countries. Of particular importance, I think, is Colombia came onto the global map last year for litigation, for standard essential patent infringement litigation in a global campaign, the Ericsson versus Apple campaign. And in particular, Colombia became important because Ericsson was able to obtain its first injunction in the global campaign in Colombia. And an injunction is, as you might understand, is extremely important for a patent owner. Extremely important to be able to get a licensee, potential licensee, to renew a license, to get them to sit down. And in that sense, you see this litigation, this practice, standard essential patent infringement practice, transforming around the world. There's daily updates on this, and Colombia was able to show that it's a worthwhile litigation. Selling Colombia was an important issue, and it's jurisdiction that's quite patent owner friendly. Another case also coming out of Colombia was a dilution case, a trademark dilution case between the parties you see there. So Banco Amigo versus Banco de Amistad. One's an actual bank, the other one is a company that sells beer. So not the same exact market, but it was an interesting case to show the potential for confusion even amongst very different classes. As far as enforcement too, I think it's important, and I'm going to the second point here on enforcement issues. There is ample discovery available. Traditionally, a lot of folks, I think, associate, oh, it's a civil code country, there's no discovery. Patent and Colombia is not the case. There's extremely ample discovery available, both to show infringement, be able to obtain a preliminary injunction, use that information and evidence in other countries for purposes of likewise infringement. So it's there's a number of interesting possibilities. Early ex parte preliminary injunctions are available without the defendant participating, which is very important for speed. Not so much for patents anymore, but certainly, trademarks. But it is an option in Colombia. There's a very strong presumption of validity. So people that typically bring up validity challenges as a defense, which is a classic defense in patent infringement, not a very important defense in Colombia. And as far as enforcement of trademarks in particular, police authorities are very active in border enforcement in Colombia. They maintain a list of trademarks and have a lot of receptivity to trademark owners being able to enforce their trademarks through border enforcement measures. There's a number of changes finally that have occurred that will impact potentially some of these enforcement issues. 2022 made it a little bit easier to challenge IP rights in Colombia, and there's a possibility there may be quicker decisions as a result of that. And likewise, this year, the Andean Court of Justice issued an interpretation where not necessarily every single IP issue has to be consulted to the ACJ. Those consultations will take time and were necessary even in cases where the ACJ had already issued decisions 15 times on trademark confusion. They don't need a 16th decision. Essentially, we've already said it 15 times. The same thing applies. You don't need to consult. And what that means is probably our IP validity and invalidity annulment procedures will be much quicker. With that, Judith, I'll wrap up and thank again AIPPI, ASIPI, and for all the organization. Thank you very much.
Thank you very much, Carlos, for that concise presentation. And I invite again all participants to put your questions into the Q&A function. And starting maybe with the first question, that would be, can you file a single trademark or patent application that can cover all of the Andean Community member countries?
It's a great question, Judith. It's been a dream, but no, it's not possible right now. There's been discussion of a single trademark application and a single patent application for the entire community. And the closest it's ever gotten that I recall, in discussions at the commission in Lima, has been a common patent application. But one of the biggest issues, well, two biggest issues really, are who gets to get the Andean Community Patent Office, right? So there's been, the same EPO discussion in the 70s was potentially being reproduced in the Andean community. So there was talk of splitting up technologies between, Bogota and Lima, for example. And as far as the trademark part, I think something that hinders that discussion are the local bars, because if you get a common trademark application, there's issues regarding there will be one country that has preference over the other. And finally, of course, there's a number of patent offices that would like, and governments that would like to keep particular control over specific sovereignty issues regarding trademarks and patents. So right now it's not possible. We'd like it. A number of applicants have expressed a lot of interest. And because of the Common Andean Community Law, it would kind of make sense to have something like that. But for now, unfortunately, the answer is no.
Okay, thank you very much. And I hope that answers the question of the participants. So another question came in, and it is there any patent linkage system like Orange Book in US in place for pharmaceutical patents in Colombia or within the Andean community?
Colombia and Peru have signed free trade agreements, and Chile, sorry, free trade agreements with the United States. Those contain an obligation to have a linkage system. But the way it's set up is you can comply with the obligation with a relatively light version of linkage, which involves, one, providing notice to patent owners that an application, that there is a regulatory approval application for a product that could potentially infringe. But the onus is on the patent owner to be verifying, to be looking for, typically it's a database, regarding potential infringement. And the second obligation is to provide an opportunity to adjudicate whether or not infringement is taking place. And well, that opportunity, that's the same one that's provided to everyone in the law. So just to give you an example very quickly to answer that question for Colombia, is the regulatory authority, the Colombian FDA, called the INVIMA, has a database where it publishes every single health registration application. And pharmaceutical patent owners have, it behooves them to be reviewing this database on a daily basis to determine whether or not, and they do this, to whether or not there is a product that's coming, that's received an application. And if it determines there is a potential infringement, it can file an infringement action and request a preliminary injunction, for example. So the part of the US where there's an automatic stay, the 30-month stay, that doesn't exist in Colombia or anywhere else in my area. But there is the possibility to review the potential for infringement and take action. So I guess, short answer to would be we're more similar to the Europeans, I guess, in that sense.
Okay. Well, thank you very, very much, Carlos, for your presentation and for answering these two questions. And with this, I would then hand over to Felipe covering the Dominican Republic and Jamaica.
Fantastic. Thank you very much, Judith. Well, congratulations, first of all, to AIPPI for organizing such very nice events, scanning all of the globe, all the IP information on the globe. And thank you, AIPPI and LCP, for inviting me to be here with this valuable audience and to speak about the experience in Brazil, Jamaica, and Dominican Republic. So yes, I have this challenge of speaking about 3 countries. And to be very clear, I am a specialist in Brazil. So I am an IP attorney in Brazil, not the other countries, but I have prepared this presentation for you with the valuable cooperation from Maria del Pilar Trancoso, the Trancoso Leroux, Dominican Republic, and Diane Daly from Foga Daly in Jamaica. So Brazil is the 5th largest country in the world. As you can see from the map, it's a very large country in South America. Dominican Republic and Jamaica are 2 beautiful islands in the Caribbean. Actually, I have had the pleasure of being there twice in each of those islands, and I truly recommend you to go there. The nature and the beaches, they are simply amazing. So I would really encourage you to spend some vacations there. Fantastic countries. In terms of official language, in Jamaica, the official language is English, Dominican Republic is Spanish, and Brazil, Portuguese. Total area in Jamaica is roughly 11,000 square kilometers. For Dominican Republic, almost 50,000 square kilometers, while in Brazil we have roughly 8 million square kilometers in total area. For Jamaica, the population is almost 3 million people. Dominican Republic, 10 million people. And for Brazil, 217 million people as of the latest poll in 2022. Regarding IP information, for international treaties, all the 3 countries, Brazil, Dominican Republic, and Jamaica, are members of TRIPS, Paris Convention, and PCT. As for the Madrid Protocol, Brazil is a member and Jamaica as well, not the Dominican Republic. None of them have signed the Madrid Agreement. Brazil and Jamaica have signed Hague Agreement, not the Dominican Republic, but the Dominican Republic is a member of the Lisbon Agreement and Budapest Treaty. The 3 countries are members of the Berne Convention for the Protection of Copyright. So this is a roughly and brief overview of the major international treaties regarding IP for those countries. As for the patents general information, in Brazil, the term of protection is 20 years, Dominican Republic and Jamaica the same. But we have the possibility of PTA or PTE in the Dominican Republic up to 3 years in addition to that. The term of protection for utility models is 15 years in Brazil, 15 in Dominican Republic, and 10 in Jamaica. Time frame from examination is in average 8 years in Brazil, but of course it depends on the area of technology. Dominican Republic from 12 to 24 months, and unfortunately Jamaica does not have this statistic. Third-party observations are allowed in Brazil and in Dominican Republic, but not in Jamaica. And administrative nudity motions are accepted in Brazil, all of the 3 countries actually, after the granting of the patent. For the patent statistics, in Brazil, last year, we had roughly 25,000 patent applications filed. So as you can see, the number is slightly increasing over the past few years, and the majority of the applicants are foreigners. As for the Dominican Republic, the majority of the applicants are also foreigners, and they have had last year around 250 patent applications, and the numbers are also increasing in the past few years. Regarding general information for industrial designs, in Brazil, we have the protection for 15 years plus 3 periods of 5 years each, in total 25 years. In the Dominican Republic, it is possible to protect for 5 years plus 15 years in total, as it is in Jamaica, the same systems. The mandatory substantial examination is not a reality in Brazil. So it is possible to obtain an industrial design registration without substantial examination in Brazil. In the Dominican Republic and the Jamaican, the situation is different. So there is mandatory substantial examination. The time frame for examination after filing is 6 months in Brazil, 3 to 6 months in the Dominican Republic, and Jamaican does not have this information from the IP office. Administrative oppositions before examinations are not acceptable in Brazil and not in Jamaica, but they are accepted in the Dominican Republic. And administrative nullity motions after the grant are possible in the 3 countries. As for statistics, in Brazil, we have had roughly 7,000 industrial design applications last year. The majority of the applicants are nationals, not foreigners, about 2/3 of them. And in the Dominican Republic, the situation is different. The majority of the applicants are foreigners, and they have had 27 applications last year. Unfortunately, Jamaica does not have statistics from the IP office. So in terms of statistics, I would have to compare only Brazil and Dominican Republic. General information about trademarks. Term of protection is 10 years for Brazil, Dominican Republic, and actually I guess this information is wrong here. It's 10 years in Jamaica as well, which can be renewed in successive periods. Time frame for examination is 14 months in Brazil, 1 to 2 weeks in the Dominican Republic. That's fantastic. I would really like to see that. That's fantastic, really fast. And about 6 months in Jamaica. Administrative oppositions are allowed in the 3 countries, as well as administrative nullity actions after the granting of the trademark applications. Registration for non-traditional marks, such as sound marks, scent, and touch marks, are not allowed in Brazil. In Brazil, there is a legal requirement that the distinctive sign must be visually perceptible in order to be registered at the trademark office. But in the Dominican Republic and Jamaica, the situation is different. So the IP office does accept the registration of non-traditional marks. I should mention regarding Brazil that although it is not possible to register in courts, non-traditional marks may be enforced through unfair competition rules. So Brazil in general, especially the courts, they do recognize the trademark protection for non-traditional marks, even though they're not registered at the IP office. Statistics for trademarks. We have had roughly 400,000 trademark applications last year. The numbers are increasing a lot, and the majority of the applicants are nationals. As for the Dominican Republic, they have had a little less than 15,000 applications, and the majority of the applicants are nationals as well. General information about IP enforcement. Sending cease and desist letters are common practice in all the 3 countries. Also, in all the 3 countries, it is possible to obtain preliminary injunctions, or as you may say, precautionary measures in order to stop a IP infringement by the beginning of the lawsuit. Civil actions are allowed in the 3 countries, but criminal actions are allowed only in Brazil and Jamaica for all the IP rights. And regarding the Dominican Republic, criminal actions are allowed for trademarks and copyrights, but not for patent infringements. Recordal at customs authorities are regular in Brazil and also in the Dominican Republic, but not in Jamaica. Although in Jamaica, it is possible to do an informal notification to the customs authority, but not a formal registration of trademark or copyrights. As for local tips and updates regarding those three countries, I should mention that the patent backlog has been significantly reduced in Brazil. So a few years ago, we had patent examined in more than 10 years, like 12 years or even more than that, depending on the technology area. But nowadays, as I mentioned, the average time frame for patent examination is about 8 to 9 years in average, of course. Regarding the Madrid Protocol, please pay attention to that. The Trademark Office in Brazil does not notify WIPO about oppositions or nudity actions, administrative nudity actions. So if you want to be advised about possible opposition so that you will have a chance to file a reply to those oppositions, you should contact a local attorney so as to follow up your trademark applications at the local office in case of applications filed through the Madrid Protocol. There are specialized judges, IP judges, in São Paulo and Rio de Janeiro state courts and federal courts. So the courts are very comfortable and have great knowledge about intellectual property while examining IP infringement cases and also nudity cases at federal court. So within those areas, you for sure will obtain a very good decision, very well structured decision. In the Dominican Republic, trademark registration is necessary for granting sanitary registrations and other marketing authorizations. So it is wise to obtain trademark registration if you are willing to commercialize your product in that country. Border measures are truly enforced in the Dominican Republic. So this is a good strategy in order to avoid pirate products in coming into the country. So you can stop them right at the border. The Dominican Republic has a Deputy Attorney General for IP matters and an IP specialized district attorney office. So prosecutors proactively assist brand owners against trademark infringements in general. In Jamaica, copyright will initially vest in the creator unless there is an agreement to the contrary. There is no work for hire exception as there is in other countries, except for works which were hired by the government. The Jamaica Intellectual Property Office administers a statutory copyright registration system which is voluntary. The newly amended trademark rules were passed in upper house of the parliament this year, March 2023, and are expected to be passed by the lower house sometime in April this year. So in the next few months, we may expect to have new trademark rules in Jamaica. So those were the general information that I would like to convey to you. Thank you very much. And thanks also to Maria Del Pilar and Diane for the support in gathering information for this presentation. I'll be here eager to answer your questions. Thank you.
Thank you very, very much, Felipe, on that one, knowing that you are in Brazil, but I think at least getting a glance of the lesser known countries of the Dominican Republic and Jamaica. Thanks for the effort making that. So again, encouraging everybody to raise your questions into the Q&A function. And we may want to start with one that is, how easy is it to obtain a preliminary injunction in an IP infringement action in Brazil?
Thank you very much, Judith. Good question. Actually, it is relatively easy. As I mentioned, especially in Rio de Janeiro and Sao Paulo courts, we do have IP specialized courts, so the judges are very familiar with the IP protection, the IP law, and the necessity of issuing injunctions. Of course, you need to have the you need to show evidence of your IP rights, and you need to convince the judge of the urgency in obtaining this injunction. But as long as you can meet those requirements, it is fairly easy to obtain IP injunction so as to stop either trademark or patent infringement while from the start. Of course, in patent cases, it could be a little tougher because making the technical evidence is not that easy. So one good strategy for obtaining the preliminary injunction is conducting a preliminary expert opinion. So you may ask the judge to anticipate the expert examination on the patent infringement and to issue the opinion. So we'll have an opinion issued by the court-appointed expert about the possibility of patent infringement. And in that case, it would be very easy as well to obtain the injunction, the IP injunction right from the start.
Okay, thank you very much for that answer. And a similar question like we had is coming in, same question for Dominican Republic. Is there any patent linkage system like Orange Book in the US in place for pharmaceutical patents? Do you know that?
Yes, well, I can answer for Brazil. In Brazil, no, we don't have the patent linkage system. I can't answer for, I'm sorry, I don't have the information about that for Dominican Republic and Jamaica, but I'll be very happy to take note. Well, if I can have the email address of the audience of the person who shooted that question, I'll be very happy to answer, or they can contact me by email afterward. I'll be very happy to get this information from Jamaica and Dominican Republic and answer properly. I'm sorry for that.
All good, no worries. And then maybe one last question that comes again to Brazil, and that is, are the border control measures effective in Brazil?
Very effective. Actually, I can tell you that the border control authorities, they do like the approach from IP owners, especially trademarks and copyright owners. It's very difficult to do this control regarding patents, of course, due to the technical issues. But for trademarks and copyrights, they are very receptive, and they actually enjoy receiving training programs. So they are open to receive training programs where you would help them to identify the counterfeit products, and you would, of course, have an official registration of your trademark or your copyright registration certificate. So yes, it is very effective in all border authorities, airports, or any of them. So yes, I would really encourage the IP owners to pursue these measures. Okay,
great. Thank you very much for answering these questions. I don't see any further in the Q&A. And with then, I would like to hand over to Agustina, focusing on Uruguay and Paraguay. Floor is yours. Thank you.
Thank you, Judith. And thank you, APPI, for hosting this webinar. It's very important for us, smaller jurisdictions in a large continent, to be able to cast a light on the relevance of our jurisdictions and to get the word out on what are the benefits and the opportunities in these smaller countries. So, as you said, I'm going to talk about the smallest siblings of Mercosur, who are, in this case, Paraguay and Uruguay. Sorry, I'm having, that's it. So to refresh a bit of geography lessons back from school, I'm going to show the map of Latin America, and highlighted in sky blue are the members, the active members of Mercosur. As Felipe has said, Brazil is one of the largest countries in the world, and along with Argentina, they are our partners in this integration process that has had its up and downs throughout history. So our smaller partner is Paraguay. I am a lawyer in Uruguay, and I will be talking about Uruguay and Paraguay. So same as Felipe said, I will be able to answer most questions on Uruguay, and in Paraguay, I'll do my best. For the purpose of this presentation, I asked for the collaboration of Lorena Merzan in Paraguay. But of course, she has not been able to teach me everything she knows. So I will start by showing some data on these smaller countries, and it can be immediately compared to the figures that Felipe has shared. Paraguay has only 6.7 million inhabitants, and Uruguay 3.4. So you can quickly see we are talking about significantly smaller jurisdictions in terms of population, and also in terms of their surface. So Paraguay has roughly 406,000 square kilometers, and Uruguay 176 square kilometers, which shows that the surface of these countries, it's a lot smaller. And this has also been part of the integration procedure and the negotiations within Mercosur, and it will explain some of the differences in these jurisdictions. But I would like to start by saying that contrary to what happens in the Andean community, Mercosur does not have a Mercosur court to deal with all of the IP matters in a supranational way, or in a forum that is international. So in each of the countries, you have to address the local courts. And in the case of Paraguay and Uruguay, there is no specialized forum for that. So this will go to the either criminal or civil justice. So this represents sometimes a challenge that we have to adapt. So going a bit further into the description of these two countries, I'd like to talk about the GDP. Paraguay has, according to the World Bank, $6,800 US GDP, whereas Uruguay is a bit higher, it's 17,000 US. And this translates a bit to the trademark payer applications, which sort of correlate with the population, the size of the countries. And you see that Uruguay has a bit more applications per inhabitant, which is in part explained by the larger GDP. So in the case of Paraguay, we have per year 24,000 applications during last year, and in Uruguay 14,000. In terms of the granting time for the trademark application procedures, I would like to begin by saying that Uruguay at the moment has shorter time frames for a smooth application procedure, but this hasn't been the case for a long time due to the fact that Uruguay has gone through a digitalization process, which for a while made the scenery look more chaotic than before. And this is usually the case when you start on with digitalizations. But in the last year, there has been a significant reduction in the time frames for the decisions of smooth trademark applications. Paraguay is still a bit behind with 12 to 15 months in the application procedures. And in terms of digitalization, as I've heard from colleagues in Paraguay, it is not significant. However, I have to say that it is possible to file trademarks online, but this is not the mandatory way to do so. And it's used and it's functioning, but it's not widely used by all trademark attorneys in the jurisdiction. whereas in the case of Uruguay, the process is entirely digital. It's not possible to file in paper applications. And also the procedure, it's mandatory for all other actions within the trademark office and patent office as well. So annulments, cancellations, office actions, responses, oppositions, it's all handled digitally. Whereas in the case of Paraguay, these other filings are done still in paper mostly. Now, moving to talk about the treaties that the countries have ratified, it's important to note, as opposing to the Andean community, that Mercosur does not have a legal base for IP matters that is the same norm as it happens with the Andean decisions, Andean community decisions. In this case, each country has its own trademark and patent law, but they share a similar base, which is well based on the treaties that the countries have ratified: WIPO Convention, Paris Convention, well, the TRIPS Agreement, Nice Agreement, and the common norm is the Protocolo de Armonización de Normas sobre Propiedad Intelectual de Mercosur, which in a way reflects the spirit of
Oh, so it seems we have lost Agustina for a moment. Let's give her a moment to rejoin. She talked about digitalization and then she moved out.
Hello.
You're back. Yes, we can
Sorry.
hear you. All good. No worries.
Where did you miss me?
You started with the Paris Convention.
Oh,
and
okay.
then-
So I was speaking alone for a while.
Ooh,
Sorry,
okay.
I am going to go back to my slide. So
Okay.
back to where we were. I'm sorry about that. Both countries, and
Would
contrary
you mind
to
sharing your screen? Sorry to interrupt.
Sorry, I thought I was doing so. Let me do it right now. Can you see it now?
Yes, we see the first slide.
Perfect. So
now
sorry about that.
track.
So back to where we were, different and contrary to what happens in the Andean community, which they share the Andean decisions on the different IP matters. Paraguay, Uruguay, Brazil, and Argentina, they do not have one common legal norm that regulates these matters. But all of their norms are sort of inspired, same as it happens around the globe in the treaties that harmonize the regulations on IP. And in the case of Paraguay and Uruguay, they are all both they have both ratified WIPO Convention, the Paris Convention, TRIPS Agreement, Nice Agreement, and they have, yes, they do share a Protocolo de Armonización de Normas sobre Propiedad Intelectual en el Mercosur, which is a norm that in certain aspects reflects the spirit of the treaties that I have just mentioned. And in terms of copyright, the countries have ratified the Berne Convention, the Phonograms Convention, WIPO Copyright Treaty, and WIPO Performance and Phonograms Treaty. So despite being different countries, they do share a similar spirit, and they sort of check the box to the IP starter kit treaties, but they are not part of PCT and Madrid Protocol. And this is very important to note, especially in terms of patents, since it will be required to file within the 12-month period of the priority given by the Paris Convention. So this is a question that we often receive when it's too late. So I wanted to highlight this, that they are not part of the PCT system nor the Madrid system. So now moving on to the relevance of these two small countries in a larger, in a region full of big neighbors, I wanted to again go back to geography and highlight this blue line in the map, which is the navigable waterway of Paraná, Paraguay. This navigable waterway connects the ports of Montevideo to Puerto Cáceres, and I'm sure you can still go up the river, but for the purpose of this presentation, I've decided to use this slide, and allows all of the load from Paraguay to go into the Atlantic. So Uruguay and Paraguay, despite not being neighbor countries, contrary to what many people think, do share some similar features, which are having been in a neighborhood with very large neighbors, and having a shared smallness in comparison to those neighbors. During negotiations in Mercosur, this allowed for some agreements that would balance off these economic imbalances between the bloc, which are mostly have to do with free trade zones and free ports that are part of Uruguay and Paraguay. These free trade zones and free ports allow for carriers to receive containers and repackage, resale, and use those zones as logistic hubs for the distribution of goods in the continent. So as you can see, going up the waterway from Paraná and Paraguay, you can go all the way up to Brazil, to the eastern part of Bolivia, and mostly all of Paraguay and the north of Argentina. And as you may be guessing by now, this is very relevant in terms of the enforcement of trademarks in the region. So understanding that these two countries play a significant role in the enforcement of trademarks is very relevant, because as you all know, it's always important to seize these goods before they flow into the retail channel. And this is always the case in any continent, but more so in Latin America, because the retail channel doesn't really look like the retail channel in Europe or in the US. This is like the Wild West. So the retail channel in Uruguay is mostly comprised by small businesses, which are very hard to find, street markets at times. So once goods in infringement flow into those channels, then we are looking at a very different picture. So what can be done for observant purposes in the Southern Cone is to register trademarks for observant purposes. This is very important because many times we get the phone call saying, we know that this is going through Uruguayan port, and the first question we ask is, do you have a registered trademark? Whenever the answer to that is a no, then there's little we can do, except when there are copyrights involved, where there is something we can pull out. But it's often the case that the goods are not protected under copyright, and we have to sadly say that there's little that we can do. And the second thing, and I want to focus my presentation on the registration at customs. This is so important that, similar to what Carlos and Felipe have shared, over 80% of all applicants in patents and in trademarks in Uruguay and Paraguay are foreign. So this shows the relevance of the goods and services that come from abroad in this jurisdiction and in this continent in general. So now moving on to this procedure, I would like to start by the good news. These procedures, contrary to what sometimes we think, do not have any official fees. So it's something that it's not very expensive typically. And that has to be encouraged between among brand owners who have goods that go through ports in a frequent basis. So what do you require to file these registrations at customs is a trademark registration in the country, in both cases, a power of attorney. In the case of Paraguay, there has to be an application by a trademark attorney and a customs broker, and the description of goods has to be that of the trademark application, which in my opinion, makes sense and does not make sense at the same time. In Uruguay, contrary to what happens in Paraguay, we have to file to describe the goods in a manner that that falls within the description of goods of the application, but that it would be understandable for a custom broker's agent. So sometimes we have those descriptions of goods that say tooth cleaning devices, for example. So in our customs declaration, we would put toothbrushes, which is something that very clear for the custom agent to understand. Of course, it has to be within the description of goods of the trademark. As for the duration of the registrations, in both cases, the duration is the same of the trademark registration, which in both cases, in Uruguay and in Paraguay, the duration of the rights is 10 years. So this new registration will have to be done with each renewal, trademark renewal at customs at the same time. And now on the legal action, according to the Paraguayan regulation, ex officio withholding of the goods, it's done by customs and it's reported to the right holder in case of imports, exports, and transits to verify its authenticity. This is one of those cases where the law says something different. I'm not sure in practice how different it really works. And this is why it's very important in jurisdictions, especially in Latin America, to always go to a lawyer in the jurisdiction, because sometimes things look differently and work similar, or sometimes it works the opposite way around. So in Uruguay, it's technically the goods are only seized by the judge, and it is only a notice that that we receive from customs saying we've opened this container, this looks strange, and there are some minutes taken. But in practice, this entails withholding the container for 48 hours or so. So this is one of the examples where I wouldn't say that that customs agents in Uruguay do not withhold the goods. They have to, because there's some small time frame that you need to decide if the brand owner is going to file a criminal complaint to have the goods destroyed eventually.
I will
In
need
terms
to
of
jump in to ask to close and come
Yes.
to an end.
And in terms of warranty, this is my last comment. It's in Paraguay, it can be required. It's not always required, but it can. And in Uruguay, it's not the case. So it's not required to present a warranty for potential damages that third parties can suffer during the withholding of the goods. So that would be all on my part. And I would like to, as I said, thank Lorena Marsan from Paraguay for the information she shared with me. Thank you.
Lovely. Thank you very, very much, Agustina, for that presentation. Again, to the audience, if you have any questions, please raise them in the Q&A function. And we have one that is, what are the most common counterfeited goods found in Uruguay and Paraguay?
Interesting question. It has changed in the last years. as in most countries, luxury goods were quite common and are still very common. But in the last years, I would say that we have seen a rapid increase of all like tech peripherals, like headphones, cases for phones. That is we are seeing it more and more, and it gets trickier because sometimes the brands come on one end and the products come separately, and this is something that they assemble along the way. So yes, we are seeing, as technology is becoming more and more part of our daily lives, we are seeing more and more technological devices being counterfeited.
Okay, thank you very much for that. And the participant already excuses himself because, again, the question, like we had 2 times beforehand, said a bit boring, but again, the same question for Uruguay and Paraguay. Is there any patent linkage system?
No, there's no patent linkage system in Uruguay or Paraguay. So the answer is no.
Okay, but clear answer, and I think that helps the audience. Okay, that was until now the question. And with this, then again, thank you very much for your presentation, Agustina. And I'm handing over to our last speaker of today, to Laura, who will cover Mexico and Costa Rica. Floor is yours.
Can you see my presentation? Hello?
No.
Oh, supposedly I'm already sharing. Let me see again. Now you can see it, no?
Now I can see, yes.
Well, thank you very much for the invite. It's really nice that this event was organized, but I have enjoyed very much learning about the region, that sometimes we think that things are very similar, but now we can see that in some jurisdictions that are quite different. My presentation will include Mexico, Guatemala, and Costa Rica. I had that cooperation of Hilda Monterroso from Palacios Abogados in Guatemala, from Ana Cristina Royabe from Ideas in Costa Rica, and from a young attorney at my office, Mauricio Galindo. Now that I'm the last speaker in this panel, I can see that we do have a lot of common grounds, but we do have a lot of differences in our region. It is important to point out that it pretty much depends our legal framework in which part of the region we are based. Since, for example, I could tell that Mexico is quite oriented to have legislations that complies with our most important commercial partner, that is the United States of America. And I think that Central America countries are like cut in the middle because they want to export or import products from the US and Canada, and also they have a strong commercial ties with Latin America. In Mexico, we do have a very, how do I say it, rich legal framework on IP. It would be our political constitution that it comes from from 1917, and since then we had protection for patents, trademarks, and copyrights included in our constitution. The federal law for protection of industrial property, the industrial property law that right now we are having like a strange system because the industrial property law was abrogated 2 years ago, and we are right now dealing on the processes depending on the date that we file or started a trial with both legislations, the federal copyright law and its regulations, the federal law of administrative procedure, the federal law of contentions and administrative procedure, the federal law of plant varieties and its regulations, and many decrees, statutes, and agreements on industrial property. We do have a lot of international treaties signed, and we have joined many multilateral free trade agreements. But I want to highlight, as in other jurisdictions, the Paris Convention for the Protection of Industrial Property, the Berne Convention, the Hague Agreement, the Nice Agreement, Rome Convention for Protection of Performers, Locarno Agreement for the International Classification of Industrial Designs, the PCT, the Strasbourg Agreement, the Vienna Agreement establishing an international classification of figurative elements, Lisbon Agreement, we do a lot of appellations of origin and GIs because of tequila, Madrid Protocol, that we were one of the first countries in the region to join, the also TRIPS, and for us, it's very important, the treaty between Mexico, the United States, and Canada. Speaking about the validity of IP rights, it's very similar to the other jurisdictions. Trademarks is 10 years, renewable for the exact same time, 10 years, 10 years, 10 years. Slogans are 10 years renewable. Trade names, they are not registered, they are published. It's also 10 years and the publication is renewable. For GIs and appellations of origin is determined the validity by the subsistence of external conditions. Patents, 20 years, non-reviewable, but we are starting with the new legislation to have supplementary years, and you have to ask for them depending on how long it took the procedure of the patent. Industrial designs, 5 years renewable to a maximum of 25. Layout designs of integrated circuits, it's also 10 years non-extendable. Industrial secrets, it's undetermined, it depends if the confidentiality is maintained. Plant varieties between 15 and 18 years, and copyrights, the economic rights is the life of the authors plus 100 years more. The recent statistics, and you can see that we are in stats closer to Brazil than to the other jurisdictions, being Mexico one of the largest countries in the region. So the trademarks applications were 196,000, the ones applied by Mexicans. We do have a huge national market, to say it in a way, 135,000. We registered 138,000 last year, and the ones granted to Mexicans were 82,000. And that's more or less the same proportion is with slogans that were 4,900, filed by Mexicans for 4,500. They were granted 3,200, and granted to Mexicans, as you can see, almost all of them, no? Trade names, that it's still a popular legal figure in Mexico, 289. Then, and as you can see, they were all filed by Mexicans and they were only granted 11. Patent applications compared to other jurisdictions, we do a lot of patent work. The patent applications were roughly 16,000, and the patents filed for Mexicans, it's only 983. The patent registrations were 9,600, and granted to Mexicans 507. I think that this is the, I will stop here for a minute. I think it's the same case all throughout the region, that we still have to work very much in innovation. We are receiving countries in patents, and I can say, as Carlos and Felipe said about their countries, Mexico is a very friendly country with patent owners. Our procedure is taking around 3 years. We have cooperation agreements with many offices in the world, and we have really improved our procedures. For this person and the audience, we do have a linkage system here in Mexico that if it's necessary, I'll talk to them that way. I will go faster because I have to go to the other countries, and time is of essence, but you can see the stats for utility models and industrial designs. which are the current challenges for Mexico? We do not have the regulations of the new law. Differently from what it's in the Andean region, regulations depend on the proposal of the regulations from the Patent and Trademark Office, and then they are authorized by the executive here in this. We're in the process of socializing, to say it in a way, the project of the regulations. Still, we do lack of certain modern legislation for metaverse and artificial intelligence. As well, we have to strengthen the copyright protection. Even though that we have a solid legislation, there are still challenges regarding copyright protection, especially in the digital environment. And also something that we have recently approved, that is the law for the the cultural heritage, and that we are speaking in this country about collective intellectual property. It's a new law. It was just issued last year, so we are doing things differently in copyrights. And one of the most important things that I think that is not only in Mexico, but in all the region, we have to encourage innovation, because as I said, we are a receiving country of technology. And even though that in Mexico, we do have a lot of research centers and so on, there are very few patents filed by Mexican nationals or residents.
3 minutes in total.
Yes. Guatemala is more or less very similar to Mexico in some things. There, I won't read every single part of the name of their legislation, but as you can see, they more or less cover the same things as in Mexico. I would like to say that Mexico has influenced many legislations throughout Latin America, but especially in Central America. So our legislations are pretty much the same. One difference that we would have with Guatemala is, for example, that the procedure is faster in Guatemala and Costa Rica. And that, for example, in Mexico, we do need a declaration of use. There is no mandatory declaration of use in Guatemala for trademarks, but they do have a very modern, and they have improved their system. As you can see, those are the validity of the IP rights, very similar to all of them in the regions. In copyrights, there's a huge difference about on the validity, but it's because it's 25 years less than in Mexico. And the amount of trademarks is quite different from Mexico. These are the recent statistics that were provided by Palacio y Asociados law firm, which I appreciate very much. And you can see that in this case, the domestic applications are less than the foreign applications, and that their applications in patent is still very, very small. Okay. The current challenges of Guatemala is the ones that you see. They are improving their electronic filing. They are digitalizing compared to Mexico, that every single thing is digitalized, and it has been for the past 10 years. They have to improve their time of response and oppositions and objections, and they do have a huge patent backlog that it's around 10 and 12 years. Going to Costa Rica, they also have a very similar legal framework, that it's, the one thing to point out here is that they do have an unfair competition law which deals with IP issues, compared to our legislation that unfair competition is included in our industrial property law. And these are the international treaties that Costa Rica has joined. And as you can see, it's pretty much the standard of the region. This is the validity of the rights, and copyrights is even less than in Guatemala, is 70 years, but all the other terms are pretty much the same. You can see the stats, and they're very similar to the numbers in Guatemala. And the percentage of domestic applicants is just 30%. So they depend pretty much on receiving work from abroad. The current IP issues that Costa Rica has to solve is that they have been having a lot of issues on uniformity of criteria depending on the examiners, and this has been an issue for foreign title holders. And their enforcement, it has to be improved because there's a lack of experience in the people that work at the trademark office. But those would be the main points that our colleagues from Costa Rica pointed out. Thank you very much. Once more, I want to thank you, Palacio y Asociados, Ideas from Costa Rica, and my colleague Mauricio Galindo, and I'm open to questions. Thank you very much. I'm sorry that I have to go in full speed, okay?
Yes, thank you very much, Laura, for your presentation. As the last speaker is always not that easy. And coming to some questions we have the first one. We are a small team of 2 software and AI developers and a lawyer entering the world of IP. What tools do you recommend we create to help lawyers and trademark owners in the fight against counterfeiting? Or first, what do you recommend we do to better understand counterfeiting issues?
Oh, that's a tough question. I think that in the region, we are still making baby steps on metaverse and artificial intelligence and so on. I think that I was very surprised as CP in Medellin last December, I think, no, it was in Costa Rica, organized a full Congress around metaverse. And I think that the first issue is that we have to teach people what is metaverse and which are the AI consequences and everything that we're talking about, the confidentiality, privacy, and more ethical issues. So the first thing that I would do is I would teach people, even there are lawyers in the region, a lot of lawyers do not are familiar with all what is happening in the metaverse and in artificial intelligence. Next step, if I want to protect something in the digital environment in the region, I will check very closely with local agents what can be protected or not, depending on our legislations, because I think that still all the region needs to improve legislation to cover many aspects that have been noticed in different jurisdictions that have much more modern legislations than ours, what can be protected and what cannot be protected. That would be my advice.
Lovely. Thank you very, very much. And as I now look on the timing, I think we need to close off the Q&A here. I'm sorry that we can't cover all, but I would like to use the last really minute to thank you all panelists who contributed, took on the challenge of the more underrepresented and lesser known jurisdictions to find out statistics, to give you an overview. And I hope that that helped you a bit of a learning experience you had. So thanks a lot for taking on that challenge and making it happen. Thanks, obviously, to all the participants, to the great questions, but we see that there is an interest of lesser known jurisdictions, and that just shows that the idea of Scan the Globe really works. Then a special thank you, obviously, to the great collaboration we had with ACP in preparing that also in the background. So it was a true pleasure with all the panelists and ACP to create that Scan the Globe session. Thanks a lot. And with this, I would like to close off the session, obviously reminding everybody that we are in preparation for the World Congress in Istanbul, which will happen on the 22nd to the 25th of October. Registration will open very soon, so pencil it in your calendar. We open on the 9th of May, and obviously we are very much looking forward to seeing you all in Istanbul. Thanks again and have a great day.